The more religious groups, they don't seem to have a fair shake in many of these rulings. You have people living in Judea and Samaria who are Jewish. They don't seem to get a fair shake from this court. And we could go on and on and on. Basically, what I'm saying, and I think what you're saying is, not so much judicial revolution. This is a judicial coup of a governmental system that was set up, and that's why they're squawking.
This is where freedom rings.
If you believe in America, if you believe in the Constitution empowers us. It's a new day. America's back. America's back, and America's going to get strong again. We're going to defend America, and we're going to defend our interests.
Liberty's voice, Levin TV.
Hello, America and Israel. This is Mark Levin, and this is Levin TV. It's a special edition, and I would call this special edition, does Israel want to be a democracy, or does it want to be a judicial tyranny? That's the question that's on the table. It's relevant to Israel, obviously, and to the United States. We have one of the foremost legal experts on these issues, both in the United States and Israel, Professor Eugene Kontorovich. He is a professor of law at George Mason. He's been at Northwestern University School of Law. He's head of the International Law Department at the Kohelet Policy Forum, a Jerusalem-based think tank. He's recognized as one of the world's preeminent experts on international law and the Israel-Arab conflict. How are you, sir?
Good to be here, Mark. Good to see you.
It's a pleasure. Okay. For the average person out there in the United States and Israel, they're hearing a lot of noise from the Israeli media, and it's bleeding into the American media and the hard left and the opposition party to the Netanyahu government, that Israel is moving right-wing into a tyranny, into a dictatorship of one or a handful of parties, particularly religious parties. What is the truth?
The truth is that Israel is moving, if the reform plans proposed by the new government, if they succeed, Israel will be moving away from aristocracy, away from tyranny, away from dictatorship, which I don't like to be hyperbolic, so I don't use these words myself, but if the current arrangement in Israel, as a result of the judicial revolution that was announced by the Supreme Court in the 1990s, is much more like an autocracy, much more like a tyranny, in that some of the most important decisions in the country, including potentially even who can be prime minister, are made by a group of self-selecting judges with absolutely no check on them and no possibility for correcting any of their errors over time through democratic or popular processes. So that it shares the same name as the United States Supreme Court. And so people think, it's like the United States Supreme Court. Maybe sometimes they make mistakes. Maybe sometimes they overreach. But it's still basically a court. It's not really a court. It is essentially a supreme legislative chamber, not picked by the people, which exercises total power over anything the government or the legislature might do. So these reforms would simply make Israel function more like a democracy, in which there is some political input, in which the people have some say in the fundamental decisions governing them.
It's interesting to me, Professor, that the people who are promoting what I'll call judicial tyranny, and we'll get into this in a moment, like to wrap themselves in the word democracy. And yet you have an election in Israel, the government won by a fairly significant majority, the government being the new government led by Likud and the other parties. You see the media attacking the religious parties. You see efforts by the opposition parties led by Lapid and others to excite governments abroad against what Israel is doing, including in the United States and Europe. And when it comes to the Supreme Court in Israel, there's nothing like it in the rest of the free world, because as you point out, I'll call it, it's almost like a Politburo, where they sit around and they decide if something is reasonable or not. The reasonableness standard, wow, you could drive a truck through the reasonable standard, particularly if you're of the left, which is everything we believe is reasonable and everything the other guys believe is not. And you point out these elections, these votes, the people have no say when you have this kind of an autocracy of a handful of people. Thomas Jefferson used to talk about the tyranny of the legislature, but he also talked about the tyranny of the judicial. In our country, Woodrow Wilson, who was a leftist, who was a so-called progressive, which I would argue is sort of a modern-day American Marxist agenda, he said the way to take over a country is through the courts, from the top down. Now, in Israel, you mentioned in the 1990s, it really started with this Chief Justice Barak, right? And he's been all over the Israeli media. He's lobbying. He's as political as they get. The new Chief Justice was meeting with the opposition party just a few weeks ago. How do you have an objective, impartial court when they're so thoroughly involved in the left-wing politics of the country?
Yeah, the Supreme Court in Israel acts in a way which would be completely shocking to American or other Western democratic audiences. It acts like a political faction. It acts like an interest group. Now, can anyone expect that there's going to be minimal due process? So this is one of the real threats to the rule of law, that the judiciary gets involved in these arguments, acting not as a court that's going to hear legal arguments at the end, but essentially as just opposition politicians. And indeed, they've been meeting with members of the opposition in Knesset who speak at protest rallies. The Chief Justice has been sitting with people who speak at the protest, the former justice minister from an opposition party. They've been having confabs. It's hard to imagine anything like this. And I can tell you, in America, recently, President Biden discussed far more radical reforms to the court, in particular, the court packing plan, which goes far beyond any kind of, which would give the legislature and the president far more power over the courts, because you can keep adding justices until you like the results. Now, the Chief Justice did not deliver a speech condemning this. They respected their judicial role. And I want to say it's ironic that people who, at least, nobody said that whether you think it's a good idea or a bad idea, no one thought that court packing is the end of democracy. It might be a bad idea because then parties change. There's going to be more court packing. Eventually, have a court with 100 people. But it's not the end of democracy. And the people who defended Biden, who said, look, the Supreme Court is acting crazy. They have this Dobbs decision. They have all sorts of things we don't like. We need to do something about it. No one said that that impulse is undemocratic. And this is a fundamental difference between Israel and America. In America, you hear criticisms of the court. People sometimes are dissatisfied with judicial decisions, be it Roe versus Wade or be it Dobbs more recently, whatever side you're on. But there's two fundamental differences. The United States Supreme Court actually has a constitution that they could purport to be interpreting. And secondly, if the people are frustrated with a decision, if they think the Supreme Court has got it wrong, the political branches have a way of addressing that. And so if you think Roe versus Wade was the worst thing ever, legalizes murder, you don't have to despair. You don't have to give up for your country. You don't have to think you have no more power. You can vote for presidents and you can vote for senators who will confirm justices who will change the result. You can say, we're trying to change the result. Just like Lincoln said after the Dred Scott case, we're going to try to appoint people to change this result. And that lets democracy continue. That lowers the stakes. And today, on the other side, if you don't like Dobbs, if you think Dobbs takes away women's rights, right, you don't have to give up on America. You can vote for presidents who will appoint justices for a different result. In Israel, that's completely impossible, because guess who controls the judicial appointments? The judges. Needless to say, they're not going to pick people colleagues who are inclined to disagree with their prior opinions. So once you have a judicial decision, there's nothing you can do. And it gets worse. You might think, well, maybe the Knesset could pass a law amending the laws that the court purports to interpret. Impossible. The Supreme Court has recently started saying in Israel that not only can it interpret certain laws that it claims, I think incorrectly, have constitutional status, they weren't passed in a constitutional method, but if the Knesset tries to amend those laws, the Supreme Court says we can determine what's constitutional. We can determine that a purported constitutional amendment is unconstitutional. So that's one thing they can do. Also, they say we can strike things down even without saying it's against the law. And that's the doctrine of reasonableness, where government action, administrative action, including who can sit as a cabinet member, who potentially considers prime minister, the Supreme Court can invalidate specifically outside of any statutory basis. They can say, yes, it's consistent with the law as written, but it's just such a bad idea. You guys don't know what you're doing in the government. You're making bad decisions. We're going to make a better decision for you. And since it's not an interpretation of any statute, you can't override it. So they are completely uncheckable currently. And the modest reforms being proposed now would seek to introduce a little bit of balance into a system now that is all checks and no balances.
Professor, let me ask you this. There's judicial review and then there's judicial review. Now, in the United States, there are limits to judicial review. You were just explaining all of the power seized by the Supreme Court of Israel. One of the reasons that is because you don't have a constitution. But still, you have justices who are supposed to be operating in good faith. Those justices know full well that you have elections, that you have a very complicated multi-party system in Israel, and to pull a government together is no easy task. And once you do it, you really have the full body politic that's involved, either against or for. So when you have a relative handful of self-appointed, self-proclaimed elitist lawyers, so they are, they're lawyers, they're flesh and blood like everybody else, sitting together almost like a social group, almost like a club, making decisions and then writing legalese around them in order to advance a political or policy agenda, that creates enormous divisions in a society that undermines the entire purpose of elections, and it creates tensions in a country. And I've noticed more and more in the state of Israel that this Supreme Court likes to get involved in who the ministers are, in who the prime ministers are, whether minor events are criminal events. We don't have anything like that in the United States. I think we'd have a revolution in the United States if that sort of thing occurred, because this clearly is not democracy. It's clearly not federalism. It's clearly not representative government. So then what is it? It's a form of judicial tyranny. So this reasonableness standard is no standard at all. I mean, I could imagine sitting there as a Supreme Court justice. I feel my views are reasonable, or I wouldn't hold them. But that's not the job. Your job are not your views. Your job is, what does the law say? And you have basic laws, I guess they call them in Israel since the 90s and so forth, that try to make up for some of this, but they don't feel bound by that either. So what is it exactly that the judiciary, particularly the Supreme Court, is in the state of Israel?
I think the judiciary sees themselves as the defenders of enlightened Western European values against a often, in their view, ignorant electorate. Now, you'll also hear some rhetoric now that, look, the judiciary is necessary to protect minority rights. There's no Bill of Rights in Israel. And there's a parliamentary system in which there's no separation of legislative and executive authority, or not much separation of legislative and executive authority. So they say, look, the Knesset has a lot of power when there's a government. So who's going to protect the minorities? And there's an important answer to that. Who protected them before the judicial revolution in 1995? That is to say, it's a mistake to think that this current system was created in 1948 with the State of Israel or in the 1950s. It is relatively new. Israel was a proud Western democracy in good regard in the community of nations before the judicial revolution. We did not see the Knesset wholesale trampling minority rights. That's one point. A second point is there's not a clear agreement on what counts as minority rights. For example, the Supreme Court has not been a great defender of minority rights. They shut down the one right-wing radio station about 20 years ago, which was operating under a license from the Knesset. The Knesset gave them a radio license. The Supreme Court said it was improper to give them a radio license. Why? Because maybe in the future, we'll run out of airwaves. There won't be like any space on the airwaves. And then people won't have jobs because we already gave them all the airwaves. So they struck down the license to the one right-wing radio station. They have not defended religious rights of religious minorities, especially the Haredi observant minorities in Israel. They have disallowed them from having events that respect their religious sensitivities with separate seating for men and women. So it's not clear that they are the best defenders of minority rights. And of course, as we see in the United States, what minority rights is a controversial question. The question is, why should a Supreme Court that's completely out of touch with the public because it's not appointed by members of the government, by democratically accounted representatives, why should they be the judges of this? And a final point is, for all this rhetoric about defending minority rights, because the answer you asked, what kind of democracy is this? Defenders of the Supreme Court, they have an answer for this. They say, when we say democracy, we don't mean your kind of simple democracy in which people are governed by representatives that they elect who, periodically have to stand for election and can be voted out of office. That's like simple democracy. Democracy requires also a protection of individual rights, some kind of limitations on government power. That's an idea that sits very well with America. I wouldn't call it democracy, I'd call it republicanism, but it is indeed nice to have written constitutional guarantees. The problem is Israel doesn't have them because people can't agree on what they would contain. So no, the concept of representative government and republicanism does not authorize the Supreme Court to say, you know what, the elected representatives of the people did not succeed and did not make a constitution. We'll make our own constitution for them and then say that they can't amend it. So minority rights here is not a very serious argument because also additionally, most of the controversial decisions of the Supreme Court, some of their most momentous decisions, have nothing to do with protecting any kind of minorities. They have to do with controlling the power of government and acting as a supervisory council for the government. As you say, who can be a minister? Details of military operations, what kind of tactics the military can use in real time. This has nothing to do with an immigration policy. How many refugees have to be allowed into the country? This is not about individual rights as we understand it. It is about supervising every decision of the government.
It's interesting, Professor, because in the United States, when the Supreme Court has really stepped out of its lane, we've had horrendous decisions. The Dred Scott decision you mentioned, upholding slavery. The court did that, and the court didn't really have the power to do that. The Plessy versus Ferguson, separate but equal is equal. The court went against a private train company that didn't believe separate but equal was equal in 1896. They wanted everybody to get on the train. The court ruled that way. In the Korematsu case, the court ruled that FDR could move 120,000 Japanese Americans into internment camps and take their property away from them. So courts make good decisions. They make bad decisions. They're made of human beings. Some of the justices are smart. Some of them are quite average. Some of them are quite dumb. We've had justices who've had dementia. We've had justices who clerks write the decisions for them. And I'm sure you've had the same thing on your court. In other words, these people are not, they're not walking on water. They're not better than the rest of the people. I think your problem in Israel is majority rights, to be perfectly honest, not minority rights. Except in the cases you mentioned. I do notice, in addition to what you talk about, the more religious groups, they don't seem to have a fair shake in many of these rulings. You have people living in Judea and Samaria who are Jewish. They don't seem to get a fair shake from this court. And we could go on and on and on. Basically, what I'm saying, and I think what you're saying is, not so much judicial revolution. This is a judicial coup of a governmental system that was set up. And that's why they're squawking.
The reforms are really not just about the Supreme Court. Perhaps the biggest part of it is, or one of the most important parts, is about the government legal advisors, of which the Attorney General is the chief. Now, important fact for American audiences to understand, when we say Supreme Court, we don't mean a court that hears appeals in cases that have been litigated in lower courts where there's a factual record and where they're somewhat limited by what they can do. The Supreme Court, sitting as the High Court of Justice, which is when it considers the legality of government action, they decide cases as a court of original jurisdiction. People go straight to the Supreme Court with no evidence, no factual record, and no standing. So basically, anyone can ask them to look at anything the government is doing, say, I don't like it, I think it's illegal, no facts, no records, just on their gut. Now, they only hear 10,000 petitions a year like that. 10,000 petitions is an awful lot, but it is because they don't have to have evidence, they don't need to have a trial, they don't need to find out the facts. But 10,000 still does not let you supervise every single aspect of Israeli life and for Israeli public life. And for that, you need the government legal advisors. So the Attorney General is the chief legal officer of the country. However, in America, the Attorney General works for the president and represents the legal positions of the government. In Israel, it's the opposite, right? The government is subordinate to the Attorney General in a very real sense. What does that mean? The Supreme Court decided on the basis of nothing, on the basis of no constitutional, no statutory text, that once the Attorney General makes a legal determination, the government is bound by it. So let's say the government has a plan, they want to pass some laws, the Attorney General says, I don't think it's reasonable, I don't think it's balanced. That's it. It's dead. So the Attorney General can veto any government action from the inception. The Attorney General can veto, can cancel government action before it even starts. And that process is replicated at every single level of government. Every level of government, every cabinet ministry, every city, every unit of government has its own legal advisor. That legal advisor is the boss of legal of that department, and the minister cannot act against an opinion of the legal advisor. The Attorney General is the boss of all the legal advisors. So the Attorney General can prevent, and there have been many cases when a cabinet minister wants to appoint someone to a commission or not appoint someone to a commission. The legal advisor says, I can't defend it. And that's it. So it's even the case that the Attorney General has argued in court, goes to the Supreme Court, and argues against the position of the government. So because the government is not really the client, the law is the client. And there have been times when ministers have showed up and say, no, that's not the position of the government. I'm the government, let me tell you. So in other words, so I think the Soviet analogy is commissars. At every level of government, there's a commissar, which ensures fealty to the ideology of the Supreme Court. And in something shocking from a separation of powers perspective, who is the chairman? The prime minister doesn't really pick the Attorney General. That is to say, the prime minister in the end picks the Attorney General from a very short list submitted by a special committee.
You know, Professor, it sounds to me like the legal bar has taken over your country. Left-wing lawyers have taken over your country. They control the ministries. Those ministry legal advisors are appointed by the Attorney General. The Attorney General has fealty to the Supreme Court. The ministers are appointed through coalition government decisions. They're swept aside anytime the legal advisor thinks they should be swept aside. The prime minister can be trumped by the Attorney General, and really, quite frankly, has to be very concerned about the Attorney General, because the Attorney General has the power, as the prior one did with Netanyahu, to take some Mickey Mouse matter and turn it into a major event and distract a prime minister throughout the entire process. And then if you appeal to the Supreme Court, well, the Supreme Court is not an objective body. It's not an impartial body. Now, one of the things you mentioned, and I just want to be clear for the American and Israeli people, there are no lanes for the Supreme Court. The U.S. Supreme Court has lanes. You mentioned them quickly. First of all, you have to have standing. You can't just file a petition with the U.S. Supreme Court out of nowhere and say, I don't like that policy, which certainly gives a group of lawyers acting as justices an opportunity to play politics. We'll take this case because we have an outcome that we want to create. We'll take this case. And I even wonder, and I don't know if in the shadows there isn't a little, maybe somebody should bring a case that's like this so we can take a look at that matter. It is so antithetical to a true legal system, to an objective, impartial legal system. And I think the left and the left-wing lawyers in your country have taken over your government pretty much, or major instrumentalities of your government, and they're backed by a left-wing media. And so they're obviously backed by Lapid and those parties. And that's what all this ruckus is about. They don't want this upset. Now, let's talk quickly about some of the proposals that are being made. You have members of the Knesset, Mr. Levin and others, What are the basic proposals that are being made that will destroy democracy in the state of Israel?
Yeah, there's a few basic proposals. Currently, the judges have control, the majority of seats on this committee that picks the future judges, right? There's 3 current sitting justices on this committee, 2 members of the Bar Association. Why should members of the Lawyers Guild pick justices for the whole country? Unclear, totally undemocratic. It's a 9-person committee, and of course, guess who the lawyers vote with? They vote with the justices of the Supreme Court, who they're going to do business in front of. They have an automatic majority right there. The proposal will give the government more seats, basically, more representation on this committee, and appoint, instead of Bar Association representatives, well, why should the Bar Association, a guild of lawyers, unelected, unpicked by anyone, frankly, not even picked by the lawyers, they don't have so many, people don't really pay attention to the Bar Association elections, and replaced by representatives of the public that would be picked by the government. So
let me stop you right there, just so people understand what a modest proposal this is. Because as you know, Professor, in our country, you alluded to it, the president nominates and the Senate confirms or doesn't. So if you had Prime Minister Netanyahu nominate and the Knesset confirm or not confirm, that's more akin to the United States system. So here you're just talking about still a committee, but shaking up the committee a little bit so it represents more broadly the body politic. And they're going nuts over that because it affects the incestuous relationship between the Supreme Court and who sits on their own court, correct?
Yeah, and even if you think Netanyahu is horrible and authoritarian, and you're not going to like the people he appoints, it's like in the this part will be like in the United States. One government will appoint one kind of judge, or lean towards one kind of judge. Another government will appoint another. And another part of this proposal, and it's considered controversial in Israel, is to have the hearings on what judges will be on the panel to be public, to have public hearings in the Knesset. Currently, this commission is a black box. No one knows what goes on in there. To open this up to public scrutiny, so judges can say, why should they have members of this powerful court? But crucially, the reform is not seeking to get rid of judicial review. The reform is not seeking to subordinate judges who will still not have their salaries be changeable and so forth. It's to have some linkage over time, like a time-delayed linkage, like in the United States, between democratic results and the composition of the Supreme Court, because judicial interpretation is a partially political thing. It partially depends on your views and beliefs, especially in Israel, where it's certainly not a textual exercise because there is no text. So that's one of the reforms, to somewhat increase the government's representation on this committee. I think that's a very modest reform, given the vast power held by the court. Another would concern how the court strikes down legislation. And here, for the first time, the law would actually give the Supreme Court power to strike down legislation. Currently, nothing in the law authorizes the Supreme Court to strike down legislation. They have taken this power on them for themselves without any limitations. So the law would, on one hand, democratically legitimize that. Say, you have the authority. We're actually giving you the job that you took. But at the same time, it will put certain restrictions on it. For example, now there's 15 justices on the Supreme Court. They sit in 3-judge panels. And there's some discretion from the Chief Justice who's on what panel. So it would require to strike down a government law instead of a 3-judge panel where there's been never any hearings below 3 judges against the Knesset. It would require an expanded panel, and it would require a special supermajority of that panel to strike down a law. But it would indeed authorize them to actually strike down the law if they can get a supermajority. Now, why is this important that they have a supermajority? In the United States, the Supreme Court doesn't need a supermajority to strike something down as unconstitutional. So why have one in Israel? In the United States, when the Supreme Court strikes down a law, it's because it's against the Constitution. The Constitution has a supermajority, right? The Constitution was adopted by a vast supermajority in an extraordinarily deliberative manner. A convention, conventions in every state, a lot of thinking, a lot of talking. The basic laws of Israel, this is a very important point, the laws that the Supreme Court calls constitutional, which are called basic laws, were not adopted by a supermajority. In other words, to pass a basic law, you just pass it like an ordinary law, and you put the words basic law in front. So they're ordinary legislation. It could be repealed by ordinary legislation. So for the Supreme Court to overrule one law as against another, it's going to need something. It's going to need something special. A third reform, pardon, would say the government is not bound by the position of its legal advisors. The prime minister can disagree with his lawyer, can get different legal advice. That's a fundamental reform. And finally, that the Supreme Court can only block government action on the basis of conflicting with written law, a statute or basic law, as opposed to simply, we don't like it, which is actually currently a basis for invalidating government action, which they call reasonableness. So it will confine them to actual laws.
Well, it seems awfully modest. You know, they're trying to paint this as some right-wing agenda to force a result. Seems quite the contrary. In other words, unlike the left in Israel that wants a result. And so they fix the system in a way where they get a result where they want. You have an incestuous relationship between the court, how future justices are chosen, the attorney general and the legal advisors and the legal bar and all the rest. This does none of that. Now,
Yeah,
what about?
There is one other provision which has gotten a lot of controversy. I think it's less likely to pass, which is called the override clause. Which, to understand it, you have to understand that when the Supreme Court said, we have been empowered by these so-called basic laws, which nobody knew were constitutional. The basic law that the Supreme Court uses for judicial review was passed 32-21, that out of 120-member Knesset. That is to say, this was not a constitutional convention. Most people didn't bother to show up because they did not know they were writing a so-called constitution until they were told. So the Supreme Court for decades has been saying, look, we're just interpreting the basic laws. If you don't like it, the Knesset can amend the basic law. They can override the basic law. That's the theory, right? Because if the basic law is passed 32-21, why can't the Knesset, with 61 to whatever, amend that basic law? So the so-called override clause would make clear that if the Supreme Court invalidates a law, a vote of 61 Knesset members could temporarily suspend that invalidation. Now, this makes sense because a vote of 61 could rewrite the law completely, let alone suspend a judicial interpretation of it. And this is not what, people describe it as a mere majority. 61 is not a mere majority. You don't need 61 votes in the Knesset for pretty much anything. You need a majority of the quorum. It's hard to get 61. 61 is to form a government. To get 61 is really not simple. At the same time, it's not clear how much this particular proposal will actually help check things, because the Supreme Court can decide 10,000 petitions a year. The Knesset can only pass so many laws. And the retail approach to disagreeing with the court, I think, is unlikely to succeed. So this law may be a bit cumbersome in a way that actually doesn't make it particularly useful. And I think it's the least likely of the proposals to ultimately make it across the finish line. And that's an important thing to point out. These are proposals. They're going to be debated in the Knesset. Some will likely pass. Some will not, like all legislation.
I'll tell you what I like about it, though, certainly in theory. It's something that I wrote about in a book I wrote about our Supreme Court called Men in Black, Black Robes. And that is, who is the final say? As you know, in our Constitution, the phrase judicial review doesn't exist. It's an implied power. We had a case, I don't want to get into the weeds, of Marbury versus Madison. But as you know, and you explained earlier, they're very limited on what the court, at least theoretically, can do in our country, as opposed to in Israel. And yet, my view is there's different types of judicial review. Judicial review that tries to apply the original intent of our Constitution, looks at the text, tries to figure out what the meaning was at the time it was passed, and so forth. And then there's judicial review of the sort that you have in Israel, which is we get to have the final say, and we'll decide how we get to decide it, when we get that decided, and what is reasonable, which really isn't judicial review, that's judicial tyranny. But there are different schools of thought between originalists and activists. Now, that said, it occurred to me that when you have a fundamental decision reached by our court, that's 5-4. Are you telling me if it went the other way, 5-4, it's not a fundamental issue? So I just felt in my own proposal, and I think this one, it's probably getting to the same point, which is 3/5 vote of both houses or 3/5 vote of the state legislatures. It can't rewrite a Supreme Court opinion, but if they act within 2 years, they can kill it. I don't believe in electing them and so forth and so on. I just feel like that way the body politic has some say in extraordinary circumstances. And I suspect that's the thinking that's going on here. I'm kind of partial to it. Whether I don't know if it would work in Israel, if it could get passed in Israel or whatever, but I get it. Now, it seems to me as I hear you speak, Professor, the Supreme Court's mindset is we are here to protect the people from themselves. We are here to protect the people from the people they elect. And sometimes they'll elect good people like Lapid and Bennett and this one, and sometimes they'll keep electing this guy Netanyahu, and we can't have that. And so we're here to protect the people from themselves. We're a governor on this process here. So in other words, they really are autocratic in mindset, and they view the public more as an uninformed mob. They view the voter as an uninformed mob. And this goes to the heart of it, doesn't it?
Well, so I don't know what they're thinking, but as a historical matter, it's very clear that the development of this judicial revolution, this power grab by the court, only began after right-wing parties began systematically winning elections. For the first 40 years of Israel's history, till 1977, there was one party in power, and the judiciary was very circumspect because it was a left-wing party, and the judiciary largely reflects that view. But there's also a kind of cult, at least in their rhetoric, a cult of professionalism. We're professionals in balancing things. We balance impartially based on justice. We consider everybody's interest, because that's a very frequent ground on which they will invalidate government action. They'll say the government did not properly balance everyone's interests. They have an unbalanced proposal because, you know, they're populist, they're accountable to the people, they're politicians. We're above politics, and that makes us, I would call it more like enlightened monarchs, like enlightened aristocratic leaders who care about the truth and the good. So they don't think of themselves as tyrants. They think about themselves they're the ones who really know.
And what about the attorney general position? Are there any proposals to make some sense out of that?
No, so for example, yeah, one of the most important parts of the proposal is to say that the attorney general can't veto decisions of the government by saying, I think they're not going to be sustained by the Supreme Court, or I think they're illegal. So the government will be able to take advice from its legal advisors and act on it as depending on whether it wants to, rather than, again, and that attorney general business is also fueled by this cult of professionalism. They're legal professionals. They're not engaged in policymaking. They're just telling some kind of higher truth. And of course, these are policy issues, especially how to balance interests. I don't know of any public interest balancing scale that you can get like at Walmart and put, the interests of one group on another and like find out who should prevail. So how you balance those interests really depends on your policy preferences.
This idea of professionalism here in the United States, people who watch my shows or listen to my radio show, they understand where that comes from. It comes from what we call the early progressive movement. About 120 years ago, really comes out of Rousseau and Hegel and Marx. And the whole goal is to take democracy away from the people. You see it in China, you see it in these other places. The People's Republic has nothing to do with the people. And so the radical left has a mindset like this. And professionalism at what, as you point out? These are basically lawyers who are controlling how your country is run. And it's not just lawyers, it's left-wing lawyers, most of whom agree with each other. Your Supreme Court I notice, is typically of one mind. Maybe there's one or two justices from time to time who say, you know, we shouldn't be doing this sort of thing. And then finally, I want to ask you, Professor, because you have written, and you've written a lot, the media in Israel. Do you think the people of Israel are well served by the Israeli media? Here we are talking about what's taking place and so forth. So now and then there'll be an op-ed, usually written in the United States, that they'll show, or maybe there'll be a prominent lawyer from the United States will speak up, or a prominent lawyer in Israel. But the overwhelming static and information day in and day out as I monitor this is to join in the opposition, to encourage protests, and even to encourage violent protests, particularly in Tel Aviv and other areas like that. Am I right or wrong? Am I missing something?
I think it's clear that the opposition is resorting to a very unfortunate tactic. Having lost the elections fairly decisively, and not having any path potentially to form a government, they find themselves in the opposition, and they find their bastion of power under assault. That is to say, for a long time, they could lose elections, but it didn't matter because policy couldn't change too much under a right-wing government because they were still controlled by the Supreme Court. Now they see that elections might actually have consequences, as President Obama said. And so they have decided to take a different route in fighting this. And that route is essentially to invite foreign opposition. Israel is a small country. Israel depends a lot on external trade. Israel depends on military alliances. Israel is very vulnerable to international pressure. And to incite a kind of alarm about this, designed to block these measures, not from within, which because they lost the election, but from without. This also involves making self-fulfilling prophecies. So that is to say, when they're saying, if we make these reforms, they're so fascist, they're so authoritarian, countries are not going to want to be friends with us. Well, of course, if leaders in the West, in America and other countries read, hey, even the Israelis are saying this is authoritarian, how can we support that? So it's designed to be a self-fulfilling prophecy, self-fulfilling prophecies of international isolation, self-fulfilling prophecies of economic harm, and they're designed to do through external pressure what could not be done through elections.
These changes that the Netanyahu administration wants to make, they'd be in place if the Netanyahu administration lost, right? So in other words, the liberal parties would, it's not for Likud per se and those other parties, it's for the state of Israel, it's for the government of Israel to try and return to a better balance, some semblance of a true democracy.
Absolutely. This does not mean that Netanyahu will get to pick the justices of the Supreme Court. This means there'll be a commission. When Netanyahu's in power, he'll have more say in it. And when the left is in power, they will have more say, and there'll be a rotation and some time-delayed lag between elections and policy outcomes. But also, more importantly, if the opposition wins elections, there's nothing here that they can't undo. This is why the end of the world rhetoric is so strange. Again, Israel does not have a constitution. These are not constitutional amendments that are being forced through that are then going to require some special majority to change. All of this can be undone. Israel has an election on average every 2.5 years. To invite international opprobrium of Israel, to defame Israel as becoming like Turkey, as some have said, a fascist state, simply out of impatience for the next election, which is likely in a few years, is extraordinary. And I think it also shows why the right has won in Israel. The right never turned its back on Israel, even when it was in the cold, right? When Israel had left-wing governments and a left-wing Supreme Court, and the right were culturally, politically isolated, they didn't say, oh, that's it, we don't like your judicial tyranny, a pox on Israel, right? So they supported Israel even when things were against them. They did not, and that's crucial. That is to say, when Jews were being expelled from Gaza, but The right did not say, you know what, we're going to get American Jews to break up with Israel, as many on the left now are urging. They wanted Israel to be strong, even if misguided. And I think ultimately that led them to be able to win in elections.
Obviously, you don't have to agree with me. These words are coming out of my mouth. But the opposition is extremely unpatriotic by going overseas and looking for opposition to their own country. Particularly, unfortunately, when you consider they can reverse everything if they could just convince the people that judicial tyranny is good for them and that their vote doesn't really matter. I see from the left and the media, the lawyers over there, that they don't believe in the franchise of voting in any significant or serious way because they feel they can always be trumped by their lawyers and by the courts. And I see this fight, at least for the state of Israel, to be the fight for its future. That is, in addition to external enemies, of which they have many, the people want to be free or not. That's the bottom line. That's how I see this fight. Even though a lot of people are out in the streets who have no idea why they're out in the streets, given the propaganda that so many people are receiving from the Israeli media. And let me just say this as a footnote, Professor. I think the American media is lousy. It's overwhelmingly left-wing. It is corrupt in the sense that it is the mouthpiece for the Democrat Party. But compared to the Israeli media, it's not nearly as bad. They do not have many outlets for the opposition, in this case, conservatives, or as you folks in Israel call it, the right or right wing, to speak. Everything goes through, is through the editing and the mindset of the left-wing hosts, the left-wing producers, the left-wing directors, and so forth. That's why I thought this show would be important. That's why I wanted to make sure the American people could see it. And that's why I will make an effort to share this with the Israeli people and those who speak English in Israel. You are a fantastic lawyer. You did a superb job. Professor Eugene Kontorovich, and I want to thank you very, very much. God bless you, sir.
Thank you, Mark. Thank you for having me on.
Take care. See you next time on LevinTV.